a chance to come and ask if there's particular things you want to learn today. Just before I get started, I know I missed a couple people, but if those of you that I talked to early on, and you remembered it after you leave, it's like remembering it at 3 in the morning, are there other particular things that you hope to learn? You're here today that you would like to learn about what to do when a death occurs. And make sure you're at that seminar. You think that you're at that seminar. So, you're going. Anything else?
Any time critical things that need to be done.
Yes.
Where there's deadlines that need.
Yep, we'll be covering that today. Yep, you're in the right seminar. Other things? Okay, well, I'd like to start by introducing the team. You've met up front. We have Carol. For those of you who ever try to schedule anything or talk to me, you've heard of the gatekeeper, Carol? Say no. Her right hand today is Collie. Collie is recent with us, so she's here to learn with you. But she had the pleasure of being in Bellevue. I've worked with her for years in another capacity, and again said, if it ever doesn't work out, call me. She made the mistake and took me up on that offer. Tori has been with us for a while. Tori is the one who works in the area of funding and marketing, hence that. So, and then Michael has been with us now for 3 months. Michael, some of you have met and been with already. Michael has had the privilege of being in estate planning for about 18 years. What else would you like to say about yourself?
What do you want to know? Open book. I've been doing this, like Brian said, 18 years. Been with the firm now 3 months. And all of that time, I've always done estate planning, always helped people navigate this type of a situation when we lose a loved one. Also do work with limited liability companies and corporations, so anyone who has business questions, I'll help answer those types of things for you as well.
If you have liked in the past and worked with our firm in the past and you like the style of estate planning we do, you'll have a wonderful privilege of working with Michael. If you do not like the style we've done, he has 18 years of experience somewhere else. You'll enjoy working with Michael. So we figured we got both sides covered. But it's been a real privilege having him with us. Very confident in his skills and abilities, and it's a good thing to be able to tag team with him. Come to a couple of seminars this fall. You'll also hear about his public speaking. So, for those of you who've been here before, you remember the intro, and that is why do we put these on? One of the reasons we put them on is to dispel myths. A lot of people hear things about estate planning, and a lot of people hear things about what to do when a death occurs. The problem is what they hear may not necessarily be what is true. So what our job is to dispel those myths, to present to you what actually happens. And that's the area that we're going to be looking at today. Another thing, and you notice that in the promotion for this seminar, was to help you, help yourself, help your family, help your friends. That we encouraged you to bring someone with you, drag them. Because what you're going to talk about may be something that's needed when you're dead. So bring in the person who will be following up after you. Helping the family is you may be here because of your parents. We keep communicating back and forth because my mom is about to turn 90, is a little bit older, and they have been dealing with the same issues. So if we went out to coffee, we'd be talking about 5 hours on loss of memory and things like that. So it's the kind of thing that we are trying to help you help other families. Last but not least, it may be a friend. You may be here because you know of someone, and either you're appointed in their documents, or you know that someone may be dying, or their parents dying, and you'd like to get information. If, in fact, you want more information, there are other handouts. We can give you duplicates. You'll learn at the end again, there'll be a video that you can put onto our website some point in time. All of those are ways to help you, help yourself, help your family, help your friends. So just be aware that that's the purpose today. And it is dealing with death. So I want to thank all of you for being willing to come out after lunch on a semi-sunny day in the spring to talk about death. Good, good. We need to talk about your choices next. So, I learned long ago, I've been to too many seminars where it goes like this. Today's topic is the preview. Oh, excuse me. What should I do first? Really? if you've been to my seminars, you know that a lot of what we do is talk about examples, because most of my clients can read. And so we don't put everything in here, we put in here the key points. But yes, real life is so much more fun than make-believe. So we hit that a lot. So preview, what are some of the things we'll be covering today? In addition to the questions you all asked, because you did do that very well, we're going to be looking at what are things you should do first. Second, how do I know what the plan is? What's going to be to carry it out? And the third is, what if I still have questions? Those are the type of things that we're going to be looking at today. And the one theme you're going to see throughout all of this is surround yourself with good people. One of our staff, who's our marketing genius, but she doesn't want any glory, put together our three-legged stool for us. With one of these gone, it doesn't really sit up very well. But a wealth advisor, a financial advisor, a CPA, and an estate planning attorney are all there together to help you through the process. I'm trying to keep you safe on the legal side. The CPA is trying to keep you safe with regard to the government. The financial planner is trying to make sure everything works right. That three-legged stool is going to become critical through the whole process. If it's you, and you have that three-legged stool already, make sure you put it in writing. And if you're one of our clients and you have our notebook, you'll know there's a section for that. It's important to let them know who you'd like to have. And if you're now in charge because someone's passed away or incapacitated, make sure you surround yourself with good people. It'll really help to have that there. So, what should I do first? That was one of the questions. It would be nice to say that settling an estate is linear. Here will be the 100 steps, and you do them first, second, third, fourth, all the way up to 100. No. There are several things that are going to be going on. But the first thing to remember when someone passes away is the first few weeks are friends, family, and funeral. People are told, make sure you call an attorney immediately. No. Friends, family, and funeral. Yes, when you get the chance, call. If it's us, there's a letter we send out. We were talking briefly about that. There are 3 parts to that letter that will help you. How do you do an inventory of the people and the stuff? If you're one of our clients, the second part is in your notebook. What to do when a death occurs is a checklist, 4 pages long, of some of the most common things that might need to apply. How do you order death certificates? Are there government benefits? What do you do with a handicap parking permit? And by the way, do not throw it in a drawer and then show it to your kids 4 years later and mention you've still been using it. And then you go, Mom, you're supposed to turn it in. She goes, that's okay, I'll just burn it. Mom, you're contractual on that thing. By then, the contract was over, she burned it. Don't ask why, but she did. But having friends, family, and funeral, surrounding yourself with good people is one of the very first things to do. Especially because if you call us and get the letter, set the appointment 5 or 6 weeks out. Because when you get that letter and open that up, the first thing you're going to say is, I do not have time for this. You're doing friends, family, and funeral. As you can gradually work through that, preparing to come to the meeting. You won't have it all done, but start working on the progress of it. So number 2 in there is contact us. Even if you're not a client, our post-death letters, we send out on the average throughout the year, maybe 3 to 5 a week. And only about a third are actually for our clients. The rest tend to be friends or family of our clients, or wealth advisors who called us and said, hey, I've got a client who's died, they don't know where to turn. Where's that death letter you have? Okay, there it is. So be aware that is something that we can get to you. Even if you're not, if it's a friend of yours, you want to give it to them, get it out of the notebook, hand it to them. If they'd like the rest, they can call anytime. We'll get that to them. Other things, look for the documents. Look and see, do they have estate planning documents? Now, one of the things that will help if they've not died is plan ahead. Ask them, where do you keep your estate planning documents? Where's your notebook? Where are the documents? Who's listed? Who do you want in control? If you have the ability to ask them, feel free to do that. Not everybody feels comfortable answering those questions. It's okay. But do look for the documents, and including in that, ask them where they keep tax returns. Because after a death, audit the last 3 years of income taxes, it shows where sources of income are coming from. So if you have the time, question?
This might be so dumb, but what is a death letter? It's not the death certificate.
No, we call it, that's what they call our letter. We send out because the third part, one is what to do when a death occurs, two is how to do an inventory. The third part is our cover letter. And we try to tailor it to the estate planning, so it would be tailored specifically to her situation, and it would talk about the things to consider in the next few weeks and years with regard to it. So it's called the death letter. It's a death letter. I don't know. No one's ever come up with a better name.
You might want to work on that. Sorry.
She's tried. And she's really good at trying. It's just that apparently the attorney's a lot more trying than she is. Okay, so getting a copy of that, knowing where the documents are, knowing where they keep the financial documents is really, really important. Especially because if you know who the financial planner is, the wealth planner, then they would be of an assistance to you also. You know who the CPA is. They'll be able to audit the last 3 years of tax returns. So many good things you can do with that. The last one is don't panic. It's really going to be an opportunity to panic. And take care of yourself. If you come to that meeting, bring someone with you. Bring several someones with you. You may not be in any shape to take notes. You may need someone else to be the scribe. Take care of yourself. When my mom, some of you know my mom was a twin. When Joni died, it was almost a month and a half to 2 months before she even tried to eat anything. No matter what we said, she couldn't eat anything. No appetite, nothing. And so make sure you take care of yourself. Surround yourself with others who will ask you, how do you eat today? Did you exercise? Make sure they're getting up. Make sure they're showering. Make sure they're going for a walk. They will not want to in many cases. But take care of yourself. You'll need it sooner or later. Probably. Three-legged stool, we've already talked about it. Make sure you get one. The tax return, by the way, is important. And the reason we encourage people to audit it is because we meet with families after someone has died. And I have sat with families where I'm here with the kids and problem child, that was close. The problem child is saying to you as the one in control, where is this? Where is this asset? How can you found this? Mom and dad said they would never sell it. How come you haven't found it? If you have the last 3 years of income taxes and it was sold, it's on there. Sold all. Go away. You want to be informed. So having someone look at the last 3 years of income taxes to know what is a source of income and what no longer is a source of income is always helpful.
What happens if you have a special needs child?
Ah, yes. Special needs where you have autistic or Downs, there's also different from accidents and other reasons. Normally, in proper estate planning, if there's a special needs child, rather than a testamentary trust, which provides maintenance, education, support, and health, the other phrase that people use is called extra supplemental care trust. It's also called the special needs trust. It also has about a half a dozen other names. It's all the same. An attorney about 10 years ago decided to come up with a new trust, a safe harbor trust. Guess what? It's been around for decades. It's a special needs trust. Anytime there's someone on government assistance, if in fact they get an inheritance outright, it will normally knock them off their government assistance. There are things you can do. It's called a D4A trust with payback. But if the parents or whoever the person who died did their planning well, in that trust will be a special needs trust, which will not knock them off of government assistance. The other thing is right after a death, when you're waiting for a death certificate, you can't get started. Will or trust, you can't get started to get a death certificate. When you're waiting for that, and there are needs of the special needs person, there are other ways where finances can be used to meet those needs through the process. The document should provide for that. So, Archie, good question. Okay? So surrounding yourself with people, making sure you're taking care of yourself, getting the letter. I was looking for a new name. Cap letter, okay. Those are things to do. Now, the next page is talking about the different types of tools people use to do estate planning. So take a second, if you did not look at this page ahead of time, look at what those different ones are. These are all tools that people may have created when they were alive. One thing to help you realize from the beginning is powers of attorney end when the person ends. We've had plenty of people come in over the years, so you've been still paying the bills. Yep, how you been doing? Through the power of attorney. Great. How will jail feel over this? It's called fraud, theft, other things. Please remember, if you've been given a power of attorney, that ends when the person ends. Don't use it. People don't like that. Institutions really don't like it. But these are the different types of tools. And like any career, my dad, as we were growing up working on a house, was the right tool for the right job. Yes. Hopefully the estate planning attorney has worked with the client to determine who's the power of attorney. When someone dies, who's the trustee personal representative, who's making medical decisions, financial decisions. But all of these are different parts of estate planning. And one of the questions that will come up later, but I want to emphasize it now, is who do you put in control? That for sometimes is really a difficult situation because you may have people that don't always get along as kids. And so what we talk about is 4 levels to look at to have someone in control of either making medical decisions, financial decisions, or helping settle the estate after someone's died or becomes incapacitated. The first, if you have kids, is your kids. But make sure they get along. Do not be the person that said, my kids have never got along, so I'll put them together as co, that way they'll have to work it out. You will be the first one in eternity that has ever worked, just so you know. So the other thing is there are times because of situations that even though they get along, putting one over the other may cause problems. I've also sat with a family and we're talking to 3 kids about which one should be in control. Mom asked the question, which of you would like to be in charge of settling the estate after we die? Simultaneously, all of them went, they both pointed to their siblings. And so immediately they said, well, would you like us to go neutral then? And they all agreed to that. They didn't want anything to come between them. I thought they just wanted a common enemy with someone else, but that's a different issue. Because the second level is other relatives. You may have a sibling, you may have cousins, you may have nieces and nephews, you may have parents that might be in control. The third is best friends. These are ones you wish were family. So you may want to put someone in control. Hopefully it's someone that the kids or beneficiaries will respect. And fourth but last is us, professionals. I mean, we're doing a whole bunch of probates, we're doing a whole bunch of trusts, we're doing all sorts of powers of attorney when they have no one else. Why? We're the most expensive. Generally going this way, gradually each one gets more expensive. But we are, because it's our job. Yet we're supposed to know what we're doing. But for those who want to stay completely neutral, that's why we do it for people. So just be aware there's the opportunity to have different choices as to who would be in control. The other thing that some people don't realize is you can put more than one together. All 3 of you. I trust you all to pay my bills. I trust you all not to unplug me too quickly. So I'm going to put you together as co, but first one there gets to make the decision. Don't let me bleed out because you can't find the other ones. That is co-or. But if you've got 3 kids and they all want to give their opinion, I'm making you co-and. Every decision you all got to do together. There are family situations where they need to do that, because they really do not have anybody else, but they don't want anybody not to be able to give their opinion. I know. Yeah, that's really fun to sell out. So just be aware, when you talk to them, if you have the opportunity before they die about their plan, these are the types of things you're asking them, what do they have? Additionally, if they have passed and now you find out, surprise, you're in control, these are the types of things you're looking for. Yes, please.
You know,
Second.
if you have a property in different states, and then I have a child in that state, and appoint one person in this state to be the so-called overhead.
Hmm?
No, I just want to explain to them that since you're in state A, and I have a son there, you take care of the activities in that state and relay the information back to the one in Washington State. Is that advisable, or you still need one overall?
Are you dead or alive?
I passed away, and then
Okay.
he stopped it.
If you pass away, we have had times where for certain assets or certain locations, they designate 2 trustees. The one that will oversee everything here, and one that will oversee X, whatever X may be. Sometimes it's property in other states. The most fun one we had someone deal with was a car collection, that he had 2 car garages, both of which were larger than my house. Okay, amazing cars. I love taking a tour up there. But in doing that, he knew his wife and kids would have no clue on any of it. So he actually appointed 5 people to oversee the disposal of all the cars, and they got a dollar figure, so motivation, and then everything else went into the trust where someone else was managing that. So yes, you can do that. You really do hope these 2 get along though.
Yeah.
But it is possible. You have another question?
So you were mentioning the power of attorney is only good while the person is living,
Yes.
and then in between the person, passing away, like let's say I'm the power of attorney right now, and then my parents pass away, and nobody knows who's gonna be in control.
Yep.
Who then pays those bills on the in-between?
Whoever has a good credit card with a high balance on it.
Oh, okay. So even though let's say my dad is passing, I'm on his account,
Mm-hmm.
but he's gone, can I still write checks on it?
Okay. She made an interesting statement. I'm on his account. My question is, how?
I went through the bank and got on legitimately.
Take her off immediately.
Oh.
If she gets in a car accident, if she gets sued, if she dies, your assets are wrapped up in her estate. If you went to the bank and got put on an account, you're a co-owner in the eyes of the bank, which means anything happens to you, mom loses money. Good powers of attorney will allow you to do that, to be able to pay all the bills while she is alive. At her death, there will be the time to get the death certificate and whatever authority you'll need in the next few weeks. Then you'll be able to manage all the bank accounts and everything else. But there will be a beneficiary designation. If it's a trust, into the trust. If it's a will, to the estate. And as soon as you are one in charge, then you'll be able to do that. So yes, with the funeral, they want you to pay that within a week. Normally, someone else puts the funeral on their credit card, and then when you have control over the money, then you pay it back. There was 2 questions, one here, one there.
So if you get off the account, because you have power of attorney, you're paying the bills, you get off the account, how do you pay the bills then?
No, you pay with your power of attorney. As long as she's alive, you pay while she's with power of attorney.
Even though you're not a signature on the accounts?
A power of attorney allows you to be a signature on the account without any incident of ownership. There's your key.
So how do you write a check?
So-and-so as power of attorney for so-and-so.
Oh, okay.
So you sign it that way on the bottom?
I do.
Oh. So
We
say
are.
that again?
So-and-so, power of attorney for so-and-so.
Okay.
That keeps all the liability right with you.
Okay, so years ago, I probated the estate for a friend, I think he worked with Ed Bowie, and the lawyer told me, unless you have virtually enough funds to pay all of the creditors, that you don't pay any of them, because if you run out of money, you're gonna get into legal liability, then you really have to put the notice in the paper, and the creditors have to, you know, apply for their fair share of the estate. So, I mean, how
They're correct.
critical is that?
That's absolutely correct. What that is called is an insolvent estate, more debts than assets.
Yeah.
And with an insolvent estate, the state statute says if these are all the debts, in the statute it says, here's first in line, second in line, third in line, fourth in line. If you can pay everybody first in line, great. Whatever's left over, you start on second line. If you don't have enough to pay everybody on second line, you pay proportionally amongst all of these
Right.
until you run out. But there are major steps you take when it's an insolvent estate. And it's very rare we will even do those because of that. And the next thing he said was there's liability. If you start handing out money and it's a valid creditor, there's personal liability that would come back on you to pay the debt.
Yeah.
Any probate that is being done, that's one of the first things of doing that inventory to confirm there are more assets than debt.
Yeah, she was smart enough all of her cash went to her daughters. So there was really virtually no cash in the estate. And she happened to own one of the premier mobile homes in Bow Lake trailer park. I got top dollar for it, and then I was able to pay all of the creditors and then have enough left over for the lawyer and, a stipend for myself. But,
Well, and the issue there is, there are people who have said to us, I have made a beneficiary designation on all of my assets. That way there won't be probate. Okay? So who's paying the funeral? Just a thought. Also, if in fact you have estate taxes to pay, the second thing they said, and this will help us to avoid estate taxes, because at our death, it's not in our names, it goes to them. Okay, both things are wrong. If there are estate taxes due, the law allows the court to go after even the daughters who had gotten all the money with the beneficiary designation. And if you had not gotten top dollar, then the creditors could have gone after the girls for the money they were beneficiary on, even though it didn't go through probate.
you know, you never know what's going to happen. You know, 6 months into the probate, I got a letter she was being sued. In one of these little bump and filed for a settlement.
That was pretty big in grocery stores, yep.
Luckily, the insurance company took care of it, but if they didn't, we would have been out $30,000 for these.
The girls would have had to cough up the money.
So Ryan, with the checking account and such, would that apply also for like, phone bills and, all that stuff? You don't wanna have your name attached to any of that stuff?
I don't.
Okay.
Now, there is another thing that some of our clients do when they have only one child. They will make a second account that may have $10,000 to $20,000 in it. That is a beneficiary designation, not co-owner, to their child. Because then they've worked it out with their child that that money, which they will get as soon as they have a death certificate, they'll use that to pay the funeral expenses, things like that, until the probate's gone or the trust is going. That works, provided you have to die in the right order. If you die in the wrong order, it screws it up. The reason you don't do that with multiple kids is because this is the responsible one. This is the one who will make sure they do everything right. This is the one I put a bank account of $50,000 to make sure they get it. Yeah, there's a problem. That person's married. And this person dies, the $50,000 is theirs. And they're supposed to pay the bills and share the rest with their siblings. But there's someone chirping in their ear. You are the only one who's taken care of mom and dad for the last 5 years. Do you know how much money we have spent on doing that? And you don't think she meant for you to have that to reimburse you for everything you've done? Don't you dare give that money to your siblings. They are losers. And the problem is you can't disagree with the person because they're right. Now you're between a rock and a hard spot. That's why it works when you only have one child. Because then the child has to fight with themselves. You should pay those bills. I don't want to pay those bills. Well, you're responsible. Don't do it. Sorry. So that's why beneficiaries during life, let your documents control it into death. Okay? Several of the things we just talked about on probate are on a later slide. You'll see. Okay, beneficiaries and joint accountants. Joint tenant with right of survivorship. Most couples together on a bank account are treated as joint tenant with right of survivorship, which means you both own 100%. If one of you dies, it all goes to the other. If we, because we've known each other for a while, decide to go into investment, we're gonna buy this apartment complex. Neither one of us, sorry, I got ready for it. Neither one of us is married, neither one of us has kids. If one of us dies, it goes all to the other. If the other one dies, it goes to me. You know, reason, kill each other off. And at that time, we say, look, if I die, you get it. That we can do joint tenant right of survivorship. But many of you know I am married. I got 2 kids. If we have this joint tenant property, but I want to make sure that my half when we die, the value goes back to Sandy or my kids, you can't do joint tenant right of survivorship. That's called tenants in common. You put it in an LLC to where we both have our units that go to our families. We buy cells. That's Michael, by the way, that does that. So we have all these different options of what to do to make sure that your wishes are carried out. But there are times when joint tenant right of survivorship is an amazing tool and works very, very well. POD, TOD. This is what I just talked about on the bank account a minute ago. That if you want a child to have money to pay bills, making them joint tenant rights or payable on debt is a great tool. Stock or bonds. Bonds are a pain in the butt when someone dies. If you ever had to deal with it, you just nod. Putting a beneficiary on there is great. Make sure you die first. We have too many people that have come to us with bonds, and the person who's payable on debt who died first. Now you got to probate. That may not be what your goals are. So make sure on any account you put a beneficiary, consider putting a contingent beneficiary in case the first one's dead. Life insurance, that has a beneficiary designation. Again, we encourage you to put more than one on there. If you are doing proper estate planning, many times the beneficiary should be to your estate plan. That way it goes into the will, goes into the trust, and it's available to pay the bills. That way it goes in there, if it's a husband and wife, to be able to fund a credit shelter trust if that's your goals. So making sure you have proper beneficiary designations. Here's the other place that would really, really sell. Bank mergers. I remember the client this morning in Bellevue before he came down. Used to be teachers from credit union Inspirus. Now it's Giza, and there was one other one in the middle there somewhere. So my first question was, okay, when was the last time you went back and made sure they still have the right beneficiary designation? Because it's been 4 different ones since they last met with me. They changed financial planners. Well, the financial planner changed, so business. In doing that, I said, okay, but tell me, when you went to the new institution, did you carry over the right beneficiary designations? Another reason to review those is because maybe kids have grown. And in the case of one of my clients, the daughters are now very well grown, and the 2 grandchildren are now about to be 25 and 28. What's the third beneficiary? Again, if we didn't learn anything in COVID, people quit volunteering to die in the right order. So making sure you have proper beneficiaries is a really, really important tool. Pensions, just be aware, you will need to find out about pensions. Most pensions do not have a death benefit with them to anyone other than a spouse. But double check. There are still some carryovers that do, but you always want to double check. Don't just cast it aside because it's a pension and you've been told all pensions end when the person ends. Well, there may be a surviving spouse benefit. There may be an ultimate benefit, you just don't know. Okay? Any other questions about beneficiary designation? Different tools people use. Okay, no estate planning whatsoever. We tend not to spend a lot of time on here other than just to cause consternation. The situation we talked about earlier of a probate where all the money has a beneficiary designation and you don't have assets to pay the bills or pay the funeral or pay the taxes. No estate planning is called intestate. There's no document. And the state statute then says who gets it. The problem is not everybody's happy with the state statute. Okay? Because the state statute says if you have kids, it goes down, well, spouse first, pardon me. If you have a spouse and it's all community property, it goes to the spouse. If you don't have a spouse, you look down to kids. If you don't have kids, you look up to parents. If you don't have parents, you look to brothers and sisters. If you don't have brothers and sisters, for nieces and nephews. They do that one more time, and then the state gets your money. Not everybody can say they like to give it to those people. I made it very clear, only one of my siblings will inherit from me. If all four of us died, now it's 5. My wife made it very clear, her sister's getting nothing from us. Okay, why? She's special needs. So we put a trust in place for her now instead. It's not outright to her. It will take care of her and then go back to where we want it to. So looking at having no estate planning, we would not have been able to do that. It would have gone to her, because Sandy's mom's dead now, and she wouldn't be entitled to any benefits, and she would have no idea what to do with this money. That's what the state would have done. Make sure you walk through what you do want it to do. This is where, if you can, and you feel comfortable, let the people in charge know what your planning is and who's going to get it. If you feel comfortable talking about this, make sure you do. I mentioned if it's all community property, because separate property does not all go to the spouse without some documentation showing them. And again, there's myths on community property. Yes, we're a community property state. So the myth is all assets are community property, and if I'm married, it goes all to my wife. That's half true. We are a community property state, but no, all assets are not community property, and that doesn't mean everything will go to my wife. Even in Washington, you have to have a document saying you want it all to go to the spouse, called a community property agreement, because the state statute tells you something different. So understanding if there's been inheritances, which is one of the times to review, a death, inheritance, a birth, or marriage or divorce, debilitating disease, those are the 5 reasons to do a review. But this is one of them. So being aware that there is a difference in Washington between community property and separate property is important. There are 9.5 states, don't even discuss Alaska with me, that are community property states. Of them, Washington, Idaho, and half of Alaska allow assets to transfer at a death without a probate. The others don't. So make sure you know what the documents are if you've moved to Washington and have assets in a different state. Make sure you know what applies to those assets. Okay? Surviving spouse. Do you want to give everything you have to your surviving spouse? Amazing how silent that was. Amazing. There are times you shouldn't. There are times you might, but not outright. For those who have an estate tax problem for the state of Washington, and yes, there was a passage of a bill, we'll get to that later some other month in another seminar. But if you're over that limit, it could cost your beneficiaries about $230,000 of state of Washington state taxes if you don't do proper estate planning. There are times, my wife, many of you know Sandy. If you do know Sandy, and you know she's recovering from ovarian cancer, just so you know her numbers are great. She did another test this week ago. We're all happy to pray for her. But for Sandy, if you know Sandy, you know a couple things. 1, beautiful. 1, great sense of humor. 2, loves Disney as much as I do. How many of you recognize when I came to see you, this is a Mickey Mouse tie? No one?
I was trying to figure out the belt.
Oh, that's even better. I'll tell that in a minute. Okay, this is a Mickey Mouse tie. These are all Mickey Mouses on this thing. She loves Disney as much as I do. At Christmas, you never buy almond roca. She makes homemade almond roca. There are people that hire her to make almond roca to take to their Christmas parties. Okay? If our kids are coming home and they've requested a meal, it's her oven-baked chicken. We don't go to Kentucky Fried Chicken. Not with that. I mean, there would be a line at my door if I died. But do I want to give it all to her outright so she can give it to the new husband and his kids? Maybe, maybe not. For those of you who worked with me, you know that's the hunk in the bimbo clause. Okay? Anyway, you never have to explain it. But there are times you want to take care of your spouse but not give it outright to your spouse. And there are other times giving it outright to your spouse is fine. Find out, if you're the one in control, what did they do? Because at a death, you might have to do a split. Because sometimes the incapacitated person is the one that survived, and you're in control now, even though someone is still alive. Looking at the documents, getting guidance will help you if there's a surviving spouse. No surviving spouse is just as much fun, because who are the beneficiaries? Look in the documents. Make sure it's clear. Do not end up with a document that says, I have 3 sons, equal shares to my 3 sons, period. Sounds good, right? The year before mom died, well, she wasn't doing well, the middle son died. He has 2 daughters. Oldest son is in charge. Youngest son goes to the 2 granddaughters and says, Grandma really never wanted you to get anything. And your uncle, is going to go to the attorney to make sure you don't get what was supposed to go to your dad. No. Oldest son came to see me. The will said nothing about what happened if one of the sons died before her. So, here's your question. Do I have 2 shares? Do I have 3? Do I have 4? Are they equal? Are they unequal?
2.
2 shares? 2 shares? 3 shares? Equal or unequal? Equal? What happens to that 3rd share?
It divides between his kids.
Okay, you put 4 shares together. Are they all equal?
Yes.
Okay? The law says, if the will does not say, then follow the state statute if there was no will whatsoever. Because all of the things you said are all of the things that they were told.
But you said, I will leave it to my 3 sons.
Period.
And there are no 3
But
sons.
there are no 3 sons, and there's no clarity of what happens to the 3rd. So the state statute says, still do 3 shares. They are unequal. The 3rd share gets divided between them. 3rd, 6th, 6th. Those of you who know me, know I talk about things that sit on your shoulders. This one's got the wings, this one doesn't. So I called a meeting, I had them all come in, and if you do know me, I do a seating chart. Put the son who's trying to get his nieces kicked out by the door. He thinks he has an escape route. Put the nieces across from you, because then the eye contact is here. It's hard to be mad at someone who's next to you. I want them to be looking at me. Put the other son over here where he's blocked off. He doesn't need to go to the door, but tell him ahead of time, do not say a single thing until I give you permission. Start the meeting. I hear you guys are having some disagreement about who gets what. Yes. Right. I hear people are saying about different people's opinions of who's getting what. Yes. Nieces, what have you been told? They repeated it, word for word. I said, really? Did you think to get legal counsel? Did you look up what the state statute says? No, this is just what we were told. Great. I would like you to know that your uncle came to me to try to make sure you did get the share legally. You could have heard a pin drop. And then I quoted them the state statute. Then you call for a break. Yeah, that was not going to be dinner I'm going to that night. no surviving spouse down to kids. Make sure if you read someone's documents, is it clear? We are sent documents all the time. Could you double check what's happening? Many times it's a kid who's giving me their parents' documents because some other attorney did it and they're not sure what they mean. Then we can look at it and go, you might want to clarify this. What do they really want? Make sure their documents are clear. Make sure they're in here and clear. Okay? Any questions about no estate planning? Briefly, we've talked about this one already, the community property agreement. With the community property agreement, it is a contract. It is when you want to leave 100% to your spouse. It is signed by both of you, and it means that there is no more separate property, and if one of us dies, it all goes to the other. This is a great document if that's your goals. If you want it all to go outright to the surviving spouse, this document is huge. There are dangers. We've already talked about the different states, but the danger is if your intent was to have estate tax protection, this will not give it to you. We both have an exemption of $2,193,000 for the next few months of estate taxes. If I die and give it all outright to her, husband or wife, I gave mine away. Now it's all her money. She's now over 2.193 and she dies, she has estate taxes. That's what the community property will do between spouses. Make sure that's what you want. It's a great document. It's a wonderful tool in the right circumstances because at a first step, this is one of the easiest tools to set. It's a really good one. Okay, next. Last will and testament. Is this what I have? Okay. I may have found an error in my document, so I was double checking that what I put in here. So I know what you guys have. Okay. Let's start on page 18. Okay, good. So, a couple things about a will. Again, whether it be a will or a trust, what you're saying is who's in control, who gets it, how they get it, and when they get it. It's supposed to be clear. Please make sure you've read it. Please make sure it understands. It is supposed to be personal of what you would like to have happen to you. There are formalities for a will. People talk about a holographic will. I wrote it down on a napkin. Isn't that valid? Not in Washington unless it's imminent death. And even then it's questionable. There are formalities in a will, and if you're going to make changes to a will, writing on it what your changes are is not the right formality. It's supposed to be the same formality as when you set it up. So be aware of the last will and testament. That's where you're saying, if that's your primary tool, who are your beneficiaries. But a will is only death planning. We talked about this in circumstances where there's a debilitating disease. There may be Alzheimer's, dementia, or some other issue where someone's not going to know what they're doing and they're going to live for many years, and you need to get a court-appointed guardian. A will does not protect against that. Good powers of attorney will, but the will itself does not. But it should state who gets it and what if that person's not alive, which is the example of murder. Other things you're talking about is who is in control. You're talking about the four that I talked about already. Kids, you're talking about a family, you're talking about friends, you're talking about professionals. In the will itself, for every client, for every person, the attorney should have asked you, is it outright to them? Is it in a testamentary, irrevocable trust for their benefit? And if there's special needs in a child, do we need to have one of those in there also if they're going to be on government assistance? There needs to be clarity. If you have the opportunity to read the document beforehand, make sure you can understand it. If not, see if you can get permission to take a look at it. You're trying to figure out what they want to say. What would they want to happen if they die? That's your goal. A will is also created to go through a probate. That's what it's designed to do. We have people meet with us that go, Mom and Dad had a will, they died, here it is, we've avoided probate. Who have you been talking to? That's what it's designed to do. A will designates who they want to be in control, but as you'll see in the next slide, you still have to get permission from the court. So the fact that you just have a will means you will probably have a probate. That's what it does. Okay? So
You
what?
avoid probate.
Look at the next slide, and after that, the slide after that is how do you avoid probate. But the next one is, what is a probate? Very good, yes. There are multiple ways to avoid probate. But what is probate? Technically, probate means proving of a will. That's it. No one thinks about it that way. Probate is like the 6 o'clock news. You will always hear the ugly ones. We're running about 100 in here somewhere, and about 80 of them, everything's going smooth. It's just taking its time. It's just going through the process. No one would ever know they're doing a probate. You got about 10 that are waiting for something. Tax returns, house to sell, things like that. Then you have the last 10. These are the ones that if you could write a book or a screenplay, everybody would watch it to live vicariously through their misery. I don't know if anybody saw the first movie of Knives Out. The only estate planning movie I've ever seen that we actually could put names to every character. It was amazing. If you want to see one of those and live vicariously, look for the movie Knives Out, the very first one. Really hilarious. It was good. But that's where those stories come in, that last 10%. For some people, probate's no big deal. It is a process where the will, the death certificate, court documents go to the court. If the commissioner likes everything, they give you letters testamentary, which is your golden ticket, to stand in the shoes of the one who died. And your job is to take their will, which is like a little satchel, and convert it into a suitcase that can hold assets. But the time, the money to create the suitcase does not occur until after they die. That's why you pay less for a will than a trust. And in this process is what was mentioned earlier, creditors' claims. It's to shorten unknown creditors and address known creditors within a 4-month period of time versus 2 to 7 years. Creditors' claims. Very valuable tool. There is a non-probate notice to creditors if you have a living trust, but there is most times creditors' claims in a probate. There are exceptions, but most times. That's your process. How long does it take? We've had some probates when it's the first one to die, 8 months to a year and a half. Second death, 1.5 to 3 years. There are those that have estate tax returns to do. Well, you file it within 9 months. Sometimes you can get an extension. The Department of Revenue has up to 3 years to tell you whether they will accept it or not. And if you give out all the money, and then say, oops, you added wrong, you owe more than back, try to go get it back from the beneficiaries. Just have fun with that.
So in a marriage,
Mhm.
if my husband passes away first, do I have to go through probate with the stuff that's now mine?
The question is, in a marriage, if my husband dies first, do I have to go through probate for the stuff that's mine? There are about 14 different ways I can answer that. The first and foremost answer is, it's not yours. That's always shakes up people really quickly. Second, you might have to, because it's how it's titled. The one I tell people to do is look at your deed to your house. The second thing I tell people is beneficiary designations on his retirement accounts. Life insurance policies at work. There are different things that may not have ownership set up properly to where you would avoid the probate. But there may be times you want to go through probate. If you're one of my clients and you've sat with me, you know this scenario, you can start laughing anytime you want to. If I kill him off, who are you going to marry?
I don't know yet.
If I kill you off, who's he going to marry?
Probably nobody,
Better be nobody. This is the hunk in the bimbo class.
I'm not.
Good luck with that. No, she would be. The next one would be. And are you okay with him giving the money to her and giving it away to someone else? There are times where couples that matters to them, they've seen it in their family line, and they don't want to give it outright 100% to the person. If you're using a will, that will warrant a probate. So the answer in 16 different ways is, it depends. How are assets titled? What are your goals? What tools have you used? All of those may be it. Which sort of lends itself to his question a minute ago. Are there other ways to avoid probate? Okay. If you'd like to talk more about probates with me later, I'm more than welcome to do that. That's the area I've been doing for 30 years, so that's my alley. Yes?
One quick one. How legal is the verbiage, if anyone can test the will or written out of?
Yeah. No contest clause. Every document has it in it. Ours has it in it. It is valid if, in fact, it's written properly. It's valid depending on what you're fighting against. If the person in charge, he was in charge last time, so you're in charge this time, if he's not doing his job right, and you're contesting that he is doing it wrong, and he truly is, then that holds up. But if the will says you get $1, if you contest it, you don't get what I left you. You lose $1? What's the effect of that? Who cares? If I think I deserve more than that, I'm gonna fight anyway. All I've lost is attorney fees. That isn't gonna help. The no contest is really trying to tell people, I said it, I meant it, this is the way it should be. Don't fight. But it's usually used because the person in charge did it wrong. So that's where you gotta be cautious. But all documents will have it. It's just one of those things you put in there. Other questions on the probate or will?
You know, nowadays the kids, they don't know too much about accounting. And then, see, the question is, when you have a married couple, one spouse passed away, normally the surviving spouse, but if you set up a family trust, goes to the spouse. And you know, there's a lot of responsibility because first of all, you gotta pay the decedent's debt. So I told my daughter, I said, get the checkbook, draw a red line, and from this point on, all the bills gotta be paid.
Mm-hmm.
And then I said, at the year end, you gotta maybe hire a CPA and have them paid by the state and tax return is due. Now, it's a big job accumulating all your, especially medical bills if you have a real problem on medical bills and all the other expenses that you pay.
Yep.
And so it's important that, you know, we attend this seminar, but a lot of time I talk to my daughter, goes in one ear, comes out the other, okay? And she said, no, I know what to do. I said, no, but you have any experience that it's gonna be a big experience as far as handling somebody's estate? Because I did it several times for my in-laws. And it takes time because you get kind of impatient, receiving all these bills you gotta pay, and the question is, you know, like we have this seminar for the people that set up the estate, but sometimes I wonder if you can hold maybe a seminar for the next level.
Well, that's part of what today was. You should have her listen to this. It'll be online. You should have her listen to this seminar online.
Okay, but the problem is, I talked to my daughter, I said, oh, but I'm working, I can't come. So is it possible to maybe have the seminar on a weekend, or evening, or on a Saturday?
That's why we put it online, is because that way she can listen to it anytime she wants to. She loses her excuse to listen to it. It'll be online. She can listen to the whole thing at that time. A lot of times we don't do the evening ones is because we found out the turnout doesn't really happen very much. And the other thing is, all of us have families that we're spending our evenings with.
What Ryan means by online is a recording of it will be posted and always available. So it's not streaming right now, but it'll be sent out in the next newsletter, so you can also share that with anyone that needs to watch it.
Right. Yeah, not just the handout, but it'll be the seminar will be on it. Yeah, that's.
A library of archives of all. Okay, perfect.
Yeah, website's got a lot of our fun seminars. Yeah, one of the ones that we were asked to do was, can you control from the grave? Darn right you can. It's beneficiary designations and estate planning. We laughed for an hour and a half. All we did was told stories about real life experiences.
So are utilities and government payments different than creditors? Can you continue to pay the house payment and your taxes without regard to what they owe creditors?
Yes, many times what they look at is in creditors, the difference between a secured creditor and an unsecured creditor. A loan, a mortgage, utilities are all considered secured creditors. Because your job as the one in charge is to maintain assets, which would mean, no, they probably don't need the TV. No, if they have a landline still, and I do, just so you know, no, they don't need that. So canceling those is fine,
Yeah.
but you need electricity on, because otherwise they'll get too cold.
You need to find all of the stuff.
Yeah, absolutely. Yeah, no question on that.
Is your website just, like, for us to go to those archives, just Rybrook Law?
Yeah, so it's reworklaw.com, and at the bottom, there's a resources tab. And so if you go to that resources tab, it has all of our handouts, all of our seminars, all of our attorney bios.
A lot of fun stuff. Good stuff too. Okay, let's take a look at some ways that people want to avoid probate. One of them is an affidavit. There are times, one of the affidavits is called a small estate affidavit. There are times when everybody that has done everything, got all the things in fine, everything that transfers where it's supposed to be, and you come across one account or one stock certificate or something that didn't transfer. For whatever reason, didn't happen. The state has put in a process called a small estate affidavit. If the value is under $40,000, under $100,000, it's over 40 days, and there's no real estate, and you've dealt with the debts, and in writing you have permission from all of the beneficiaries, then you can do a small estate affidavit to claim the money instead of doing probate, which is about a quarter of the price of doing a probate. So it's actually a good thing. The other is a lack of probate affidavit. This is usually designed between husbands and wives, where everything was supposed to go to the other, and then they looked on their deed and it just had their names as husband and wife, and they thought they owned the house together. No, they didn't. You owned half the equity, he owned half the equity, not together. And the title company wants to know, why do you think he should get your half? You should get his half. Well, a lack of probate affidavit is one that can be used in those circumstances. They would really like to see a will that also says you should get half. So there's still times those affidavits can be used. So those are just other ways, other things at a death. If you've gone through all of the inventory and all the assets, and you come across one or two things, don't just jump to the fact, oh, we gotta do probate. Probate is usually done because someone has died, there's an asset in just their name, and it didn't pass to someone for whatever reason. So now the court's got to get involved to get someone appointed to have the authority to transfer it. These are two of the other ways to do that. Question?
So if they have no will whatsoever, does the small estate affidavit still work for that?
Yes.
Perfect.
It's the lack of probate affidavit with the property between husbands and wives. Sometimes they'll let that go through, but if you have multiple pieces of property, you're better off doing probate. Because you don't have the authority to do a quitclaim deed when you lack a probate affidavit. It's in lieu of that. Other questions on affidavits? Okay, revocable living trust. I want to do a disclaimer. More people understand wills than understand trusts. Because of that, there will be more time spent now on what a living trust is over what a will was. That is not in any way, shape, or form to say that we think people should have a trust over a will. It's just the issue of clarification. These are two different tools that accomplish two different things. And for anyone that's our client, what we've said to you is, why are you doing estate planning? What do you want the tool to accomplish? And if you've done our charts as a husband and wife, there's 4 different charts. Do nothing, I love you will, marital trust, living trust. And it gradually shows more of the goals. And I tell people, when you do that, go to the tool that meets your goals and stop. Now, my bookkeeper might like you to spend more money on something you don't need, but you shouldn't. I compare that, now mind you, I grew up in the 70s, and back then, sunroofs leaked. I compare that to buying a sunroof on a car in Washington State. All my friends in high school and college have got a sunroof in their car. All their cars smelled like mold. They all leaked. Apparently they're better now. You do a moonroof, not a sunroof, and all this other kind of thing. Fine. Not back then, and that ruins my example. But that's the case. So when we challenge you to think of what a living trust is, let's go back to what I said about a will. The will is a satchel that through a probate converts to a suitcase, and after the death, through the probate, you fill the suitcase up. For clients, for whatever reason, that do not want to wait until a death, they choose to do a living trust. I will create the whole suitcase now. And while I'm alive, we will transfer assets into the suitcase. If you have property in more than one state, then property in all states can go into the suitcase. And you still can put a provision that the one in that state would resolve how that one's supposed to be disposed of. But the living trust, you're spending the time and the money now, so it doesn't have to be done after the death. That's why we compare it to a teeter-totter. But to do the trust and not to fill it up defeats the whole purpose. That's why our funding department has letters that say, do not die till you get this done. I actually wrote it that way and she changed it to be nicer. I don't know.
A certain amount of money to do a living trust?
Yes, whatever it costs to pay for it.
Oh, okay.
I've had clients who've had $100,000 that do a living trust because in their family, his number one goal was a will contest. Every generation for several, there are multiple fights every time someone died because it was a probate, it was in the court, and it was public record. They came in and said, I don't care what it costs. I don't care what assets I have. I want nothing in the courts. I want it private. Okay? It's, for us, it has nothing to do with money. People ask, is it estate tax limits? No. You can do estate tax protection in a will. It just means you'll have two probates. You can do it in a trust, which means you spent the time and the money now. I love it when people come in. I would like the easiest tool. Really? For when? For you to set up first death or second death. Oh. Is that different tools? Yeah, 3 different tools. Oh. Well, I'd like the least expensive tool. Great. For when? For you to set up first death, second death. And guess what? Those 3 are not in the same order as the first one. It always comes back to what are your goals and desires? What is it you want your estate plan to accomplish? The easiest, quickest thing to put in place is a will. One of the easiest, fastest way to settle an estate is a community property agreement. But the will is going to result in a probate. Community property agreement may result in estate taxes or go to, it won't all go to your spouse because it's going to go to their new spouse. It's your goals. It should never be the attorney. I cannot tell you how many times I've had clients come into me for me to review their estate plan. Great, what do you have? I read it, says, do you know what it does? Not really. Why do you have it? The attorney told me this is what I need. I'm sorry, on behalf of all the attorneys around the world, that you were told that. Because that means the attorney's not educating you. It is not my job to tell you which tool to get. The job is to tell you what they do. So if you're helping yourself, help your family, help your friends, you're looking at what to do when a death occurs, look at what is the tool they have. If they have a community property agreement, that's going to be easy between a husband and wife. If it's an individual or a couple, if it's a will or a trust, understand there will be different ways to settle the estate. By looking at the tools they have will help you to know what work will need to be done when you die, or when they die. If you die, you don't have to do anymore. So that's why a living trust is one of the tools, depending on what their needs are. It may be they are concerned about incapacity, and they know they don't want you to do guardianship. Then you may need to look to a living trust. That's what you're trying to find out. If you have the opportunity ahead of time, please do see what they have. If you don't, and then you're going and you find the documents, this will hopefully help you understand which process you might have to go down. So that's why we cover the different tools, so you may come across a small estate affidavit, a lack of probate affidavit, a community property, a will, a trust. All of these are different things you may come across. This will hopefully help you to know what steps you may need to take. Okay? Any questions about that? Because the next slide is, I have other questions. How appropriate was that? These are 4 of the most common questions we get asked in settling estate. The first one is the most common one we're asked when we settle estate. Can I get paid? Yes. I encourage individuals to keep track of their time from the minute the person dies until everything is all done. Keep a spiral notebook. Be clear and concise. The date, the minutes you did it, not just 8 hours this day. Really? You never slept, you never took a break, you never pushed a phone call, you didn't eat? Okay? The time you spent doing that. If you traveled to do things, you can get reimbursed for mileage, but you cannot reimburse yourself for mileage and get paid for the time. Be cautious on that. Look to see what hours you do. Even if you say, for the good of the family or my friend, I will not pay myself. Do not be surprised if you spend 350 to 750 hours to settle the estate. It all depends on the circumstances. Real estate, taxes, probate, all those will affect how much time. Stinky relatives, those that are fighting, all that will affect your time. You can be paid.
How do you figure out what would be reasonable?
It's usually between 50 and 100. Many times people will say, what's reasonable? Well, what would they not fight me on? If they threaten you because you're charging too much, say, great, I'm resigning, you're now in control, have a good time, and you only get $20 an hour, because that's what you think I should be paid.
So you're saying $1,500 an hour?
Yep. Yep.
Yeah, when I agreed to probate this woman's estate, he said, it's gonna be a piece of cake. All you have to do is keep my daughters from fighting. And I don't know if you remember Donna Hume from the University of Washington rowing team. He was her boyfriend. He lived with her in Bow Lake. And I would go in there trying to go through her effects, and he was still there. I actually had to force him to leave.
Yeah.
He did not want to leave. You know, so you just, there's all, you know, and I spent hours and hours on it, a lot of time that I didn't think I was going to have to, so, you know, even.
If they say it's gonna be a piece of cake, go down to Claim Jumpers, and when you walk in, you see that chocolate thing that's like, you know, yay high, like yay big. Yeah, that's the cake we're talking about.
Yeah, the one thing that I did is I put a sign, a for sale sign in her trailer, her mobile home. And by the end of the day, I got a call from Bow Lake saying, you can't do
You
that,
can't.
that's illegal.
Well,
So, you know, luckily it was up long enough for somebody that drove by that had been looking at that lot for years, waiting for it to come on the market.
yeah,
So that's how come I got top dollar for it.
that's how you got that sold. Good job. Yeah, that's one of those things being paid, and I, anytime someone says there'll be a piece of cake, I just go, what if it's too much work for me? Resign. Just because you're the one designated doesn't mean you're the one's gonna do it. You don't have to. It's your choice. If you're one of our clients, you'll know we ask for 3 or 4 alternates. Why? Because at that time, the person who you've asked to be it may not be alive or may not have the time to do it. Who knows what's going on in their life? Could be anything. Put alternates in the documents, make sure who your backup is, and frankly, if you don't want to do it, don't do it.
So you said a range of price. Can you state a price in your documents, what you're willing to pay?
You can, I don't. Reason I don't is because someone's gonna be mad. If I say you're gonna get $50 an hour, it is gonna be so much time, so many fights, so much everything, you're gonna resent $50 an hour. If I say $100 an hour, and it's easy as all get out, it's hardly doing anything, all the beneficiaries are gonna resent it. That's why people don't usually put a dollar figure in there. 2 things happen. My personal representative trustee is gonna get $20,000 to settle my estate. That was written wrong. When does she get to be paid that? As soon as she takes it over, get your $20,000 behind. Or it isn't 350 hours, it's 750 hours. She gets 20,000. She kept track of her hours. It'd be about $40,000. Who's mad now? So you can, we discourage it. California, they have a state statute. This is what the attorney gets. This is what the personal representative gets. I don't know anybody, except the one who got paid that, who's happy with that statute.
But you do recommend having it in the will somewhere that that person shall be paid.
In living trust, we put it in there. In the wills, it's a state statute. It's in law already,
Oh, interesting.
codified. Okay, I forgot about this question. I love this question. What if I don't like the distributions? Quit. Tough. You don't have a choice. You're gonna get sued if you do it wrong. And we have had situations, usually it's some form of a charity, that the person that's doing the settling goes, they changed their mind, they didn't like them anymore, they didn't want to give it to them. Well, that's interesting, they never told me that, and I drew up the document 2 months out of when they died accidentally. No, if the document says it, that's what you need to do. Is there a way to change it? Yes, it's called TEDRA, Trust Estate Dispute Resolution Act. The problem with that is, the beneficiary who would have gotten the money has to sign off the document saying they're willing to not get the money. Which charity is signing that document? None I know of. So if you don't like it, don't do the job. That's it. Bottom line. Okay. Can I get help? Not only can you get help this way, you can hire people to do different things. Mind you, we have had this person has tried to get paid, hired some other people to do things, tried to get them paid. It ended up being like 30,000 hours or something like that. It was like $50,000 because they didn't get the beneficiary designation they thought they were getting. It went, that doesn't work. You don't get to do that. But you can and should hire a CPA, a wealth advisor. You can hire companies to move it out and take it to the goodwill of the dump. You can hire others to do the yard work. You can hire people with the estate money to get the estate settled. Yes?
Another question, if we have the trust document will established by you folks, upon death, should we contact you folks, work with you folks?
Loved it. Absolutely.
Can you repeat the
The question was, if their documents are with us and they die, should they call us? Yes, you should, because then we'll have the rest of that letter in addition to what's in the notebook. So absolutely, we can help walk that through. That's the area that we do. And both Michael and Amber are both working in those areas of trust administration and probate. So if I drop dead, you have other people in our firm who's going to be able to handle those areas. So definitely we can do that. And even if it's helping settle someone else's estate, we can help you with that too. There's attorneys that hold on to your original documents for you, for your benefit and goodwill and lack of destruction of them. Malarkey, when you die, they'll convince you why you have to do the probate through them. No, you go wherever you want to do the estate administration and the probate. We give all of our clients the documents. If you don't want to come back to us to settle the estate, go wherever you'd like to. Take your notebook. You have all your documents. If you'd like to come back, just come back to us. But that's what you can do. You can get help from an attorney, from a financial CPA, and others to help settle the estate. It is all there available to you. Absolutely.
Yeah, our first will that we had drawn up, the attorney kept it. And then I think he went out of business or moved his practice or something, and there went our will.
Yeah.
We had no idea where it went.
Yeah, you will see that in the Bar Association every time. It's in almost every month. So-and-so has died, they lived in this area. If you happen to know if you've ever done an estate plan for them, will you please call us? The family thinks there was done and no one can find it. There was a prominent attorney in West Seattle who at one time talked to us, we were going to buy his practice so it could continue on, and couldn't come to terms, was fine, we just went our way. and I heard about a month and a half later, he shut his doors, locked them. Him and his wife, I think, are in Arizona now. Do his files have originals in them? No one knows. Like, oops. So, no, you should have your original documents. Okay? Other things in here, I forgot to put in my favorite business card. Because some people don't like my favorite business card. But if you see my favorite business card, you'll know why they don't like it. It has a tombstone on it with you. And it says, check in before you check out. Well, one they'll teach you one later, even though they don't like it as much as I do. It was my dad's before me. Anything you can learn while the person is still alive, if they are comfortable talking with you about it, will help you out of death. So if you can, and you know you're the one settling it, do what you can to see if you can learn things. At least who are their advisors? Where do they keep things? Even if they don't want you to see what it is or how much is there, those two things will be very, very helpful. Who are their advisors? Where do they keep their documents? Okay, we have a few minutes left. Any other questions I did not cover?
Do you still work out of the Bellevue office?
Yes, we're on 40 Lake Bellevue. We have different days of the week. I'm there on Thursdays, except this afternoon, but I was there till noon. Thank goodness there was no traffic, and which is rare. But yes, and then Michael's there on Wednesdays, sometimes when it's filled up. And Amber's not sure yet day after she passes the bar, which she'll be there. So we all do take a day up there. Many times I'll have 5 or 6 appointments in one day, just because that way they don't have to drive south. Other questions? Well, when was the last time we went to a seminar? I did it 4 minutes early. Okay. I will be around, Michael will be around, team will be around. If you want to do a review of your estate planning documents, or if you'd like to meet with Michael or myself, then the ladies have a laptop that's connected apparently. And if you want to set something up, if you recall, we do not charge for our initial meetings or reviews. So somebody will just get things reviewed, because make sure everything's up to speed. So, thank you for coming. We're going to hang out for a bit. Glad you're here.
Great job, thank you.